Hey, hey, we have another circuit court case. Very helpful in terms of the point it drives home. This was not a remand like the one we had recently, which was a real sweet thing. This was where the claimant lost, which is often the case when we see these, it seems. Okay, so this is the Sixth Circuit. Um, we have several circuits, and this one hasn't been discussed lately, so nice to see a Sixth Circuit case. This came out end of October 2024. It's Robbins versus the Commissioner of Social Security. Presumably that was Commissioner O'Malley, but as I've said elsewhere, it doesn't matter what the commissioner's name is. They come and they go. And when the case comes out, it might be a commissioner that wasn't even there when the original alleged wrongs were done, or alleged rights, as it turns out. Okay, what's interesting about this one, maybe why Adriana brought it up. I don't know. Maybe she does all circuits. I don't know. I'll have to check that out because they're truly of great value, what she does. This is about a young man with autism. We got a lot of calls and emails, people seeking representation for a younger person with autism. And they are not easy cases to win, possibly because almost everybody's labeled with autism if they're a little bit different. I mean, there might be a little overreach on the diagnoses, which does not, again, as always, when we overreach with labels and, try to make the whole world into one basket, we tend to do an injustice to those that actually have the true McCoy. All right. So here we go. In this case, the circuit court upheld the denial. So this means the ALJ denied. The appeals council, when it was requested by the claimant to review the ALJ's decision, declined to review. And the claimant took it to federal district court, which also denied, their appeal in terms of substance. And so then they appealed it up to the Sixth Circuit, would be my understanding. Okay. So the claimant argued that his autism, his name was Robbins, remember? His autism prevented him from working, and he cited struggles with concentration, self-management, and independence. As per Adriana's great summary here, the ALJ denied his claim, as we said, finding that he only had moderate, okay, keyword guys, moderate limitations in the key areas under SSA's criteria, despite acknowledging his severe impairment. So the ALJ found he had a severe impairment of autism. However, when we're trying to argue that our mental health impairment is so severe that it prevents us from working, one thing we do is we look at the four broad areas of capacities, mental capacities that are required. Each of the four is required for arguably any occupation of the 12,000 plus occupations, and which includes the simple 1-2 step, easy, no skills, fourth grade jobs, etc. From a mental capacity standpoint, not a physical. So you can have nothing wrong with you physically. But if any of these four broad areas, you have suffered a substantial loss in the capacity to perform those tasks, those mental tasks, then in theory and in reality, if everyone agrees with you that's making the decision, the person would be disabled from all jobs because those tasks are inherently necessary for every single job that counts, the jobs that count, substantial numbers in the economy, etc. Okay. As it turns out, generally to find that a person is not, has a substantial loss in the capacity for a particular area of the four, they use terms like mild, moderate, marked, and extreme. And anything other than marked such as moderate, is not going to get you where you need to be in terms of establishing a lack of capacity to perform that broad area needed. So, and generally they talk about 2 areas with marked limitations or 1 extreme. They have definitions for those, but I won't go into them here. But when you see that an ALJ or a medical professional's opinion puts everything at moderate or less, you're gonna, if they find that to be accurate, you're gonna lose, at least on the mental health part. So that looks to be what might have happened here, because the ALJ found that he only had moderate limitations in the key areas under SSA's criteria, not marked or extremely limited, just moderate. We don't all necessarily find this to be logical. Anywho, she goes on to say that the court's findings are, where the court focused on Robbins' functional limitations, agreeing with the ALJ that Robbins did not meet the listing for autism. So remember, at step 3 in the sequential evaluation process, and I have a playlist on all the steps, if you want to look under sequential evaluation process, SEP, they look first to see if you meet a listing. After, earlier than that, they found out you had a severe impairment. Okay, severe impairment doesn't mean a listing. If it doesn't mean a listing, then you're not going to win under a listing, and you got to go do it the long way, which is the RFC, residual functional capacity way. And that talks about your specific functioning and the evidence that shows what you can and cannot do. And that would occur, they're going to give you the RSC after they deny you for the listing. They're going to figure it out under step 3 before they put you on to step 4. Once they have your RFC at step 3, they put you on to step 4. If you have past relevant work, can you do your past relevant work? Okay. And the rest of the steps are in that playlist. She notes that evidence like his ability to complete college courses and handle routine tasks supported this finding, even against testimony from his mother and treating psychologist. You know, it's funny, I have a case similar to this, although it's not autism. And it almost sounds like the ALJ made the same kind of findings, contrary to the long-term treating pediatric neurology chief of staff that we had that have been treating him forever, including when he was an adult. So yeah, there's like an aversion, I feel like. But completing college courses, you know, people sometimes ask, if I go to college, will it take away my disability, or will it make me lose my case? And, you know, we have some videos on that. And obviously, if you can blow through full-time college, it's going to be more of an uphill battle. Although there are arguments, sometimes there's a lot of accommodation, etc. I don't want to go into that here, but that's cases where we're not trying to prove the person is mentally incapacitated from all jobs, all of them, even the most simple 4th grade jobs. When we're normally talking about college courses, we're just talking about, will it bump them out of the slightly impaired level of concentration that we're arguing they have, that they have a little bit of an impairment there. Not where they can't, you know, function otherwise, but that would eliminate the high-end jobs we're trying to carve out, where we don't have to necessarily carve out the low-end jobs. So it really depends on the case, and what path is your path to disabled is how you kind of need to look at it. They're not all going to be the same, and they don't all need the same proofs, and they don't all need to prove the same things. Okay. And grids go into that a little bit. You know, vocational profiles affect that a lot. And apparently there was evidence that he could handle routine tasks. That's kind of a vague, you know, a vague terminology. Routine tasks. What kind of, you know, you could have a routine that's 20 steps, you can have a routine that's 1-2 steps. So, but truly, you know, to say you can't handle routine tasks would mean you can't handle 1-2 step tasks, you know, all throughout the day. Like that would be, you couldn't do a routine. And again, that is a very, very majorly impaired person. And that does kind of maybe conflict with someone who has the ability to complete college courses, particularly if unaccommodated. All right. The ALJ determined that Robbins could handle simple, low-stress work. The court upheld this RFC assessment, emphasizing, and this is important, that substantial evidence rather than perfect evidence supports ALJ decisions. I like the way that is explained right there because substantial evidence is such a nebulous concept sometimes and gets people very aggravated. Because as we talked about in recent cases, if the ALJ's denial or award, but obviously if it's going to be appealed by a claimant, it's always going to be because it's a denial. If it is supported by substantial evidence, not necessarily every piece of evidence, but substantial evidence, then it under the law is supposed to be upheld by the appellate court. And the way they say that, substantial evidence rather than perfect evidence. I like that because it really shows and explains, not, believe me, not that I like that anyone gets denied, that shouldn't. People that have the idea that, a decision can't be made unless the evidence supporting it is perfect, 100%. Even in criminal cases, guys, and we have beyond a reasonable doubt, that doesn't mean 100%. I would argue it means pretty darn close, but there is a small amount of doubt that is allowed to linger and still find someone guilty of a crime. It just can't be a reasonable doubt. So there has to be something less than a reasonable doubt left over lingering for the conviction, right? Okay. Or for the vote of guilty. Simple, low stress work, that's always funny because we know simple jobs, but low stress work is somewhat in the eye of the beholder, isn't it? They'll say, oh, being a cashier at a grocery store, low skilled, low stress. Is it really low stress? If dealing with customers stresses you out, it's not really low stress. So for some people, being able to show up punctually on time for a job without interference from other physical or psychological symptoms, just showing up is very stressful. And by Friday, that weekend is really, a saving grace. And it can go on obviously week after week after week for X amount of months on a sustained basis can be tough. So it is that is a little nebulous word too, low stress. I mean, we kind of know what it means, but again, the question is, what is low stress? I mean, and it's very much in the eye of the beholder. I mean, I look at my job, some people would say, well, that's a very high stress job. Okay. However, for me, I don't know, it's not. Not that there aren't moments, but it all depends on how you have adjusted to it, I suppose, right? Like if I was put in here yesterday, I would be probably in a fetal position in the corner. But, so really the low stress work, I feel like simple is more understood than low stress because low stress is so dependent on the worker, right? Pretty much. Okay. But that is what it is. The court did uphold the RFC assessment of the judge, emphasizing that substantial evidence rather than perfect evidence supports ALJ decisions. I do totally get why that has to be. I know some people out there want a appeal court to be able to render an entirely new decision, rejudge the evidence. And that is not what appeals are generally about. I mean, when you go from a reconsideration to the ALJ, yes. And the ALJ explains that at the beginning of any hearing. It's a de novo review. He gets to re-review and reweigh everything he wants. He can look at it any way he wants it, every piece of evidence. That is not the same with an actual appeal in court. It's just not. The court discussed and she makes it funny about this later, the zone of choice, and said that choice belonged to the ALJ, not the court thereafter. And having a decades and decades of appellate practice, I totally get the deference given to the ALJ's findings, short of the ALJ violating some step that had to be because if not, every case in every venue, and I'm not talking SSD, would be never ending, and there would be no justice. Okay, one way or the other. She goes on to say, there are some takeaway points from Robbins. Substantial evidence standard, which we've talked about a little bit recently. Courts defer to ALJs if their decisions are supported by reasonable record, even if another conclusion is plausible. Remember, there's always multiple possible conclusions. Is the one the ALJ decided on, is it reasonable? It's not going to be, necessarily universal or exclusive, and there's no other possibilities, but is it reasonable to come to that conclusion? You have to have some sort of basis like that, or else, again, nothing could ever happen. You may as well just not have an ALJ at all. And then be careful what you wish for. Okay. Balancing expert opinions was another takeaway point. ALJs can discount treating doctors' opinions if they conflict with activities or other evidence, such as Robbins' ability to complete college. So, having not read this case yet, I'm wondering if then the ALJ may have discounted his treating doctor because other evidence indicated that Robbins had the ability to complete college. That's what that sounds like. And if you might recall, 2015, 2016, there was a big push for a change in the rule about the treating provider opinion. It used to be where the treating provider, if his or her opinion on a particular limitation, severity, that kind of thing, if it was well supported by the record and not inconsistent with the record, and or his own records, well supported by his own records and not inconsistent with the rest of the record, then his opinion had more weight because he was the treating provider with a durational, viewpoint that had kind of some substance behind it. It wasn't a one-hit wonder exam like with a consultative examination doctor, or one that just reviewed records and made an opinion, like the medical experts in the SSA when they develop your RFC. However, in the mid-teens of the 2000s, 15, 14, 16, there was that big push by some to change that rule. And that rule did in fact get changed at that time to make it where the treating provider did not carry more weight, even if his opinion was well supported, not inconsistent. They could explain why they don't, and why they decided to jump on the bandwagon of a one-time hit examining doctor. Okay, we didn't like that. At least most practitioners did not, and certainly most, I would believe, all claimants. Didn't like it at all, and it didn't come to be. They created it, they made it final, and then they made it effective in early 2017. Interesting, right? It is funny how they pick when they're going to make things effective. Okay, the last thing, proving functional impact. This is one of her take-home points. Severe conditions alone aren't enough. Claimants must show functional limitations meet SSA's strict criteria. All right, this is probably haven't done a video on this in a long time, but I used to hone on it a lot, and they're in the one of the playlists up there. I think if you search under diagnoses, I'm not sure which, in the title, you'll find it. Severe conditions, aka diagnoses that are severe impairments, they don't win SSD cases, them in and of themselves. It is the medical evidence of how severe they are and how severe the functional limitations are that render you now with an RFC that says no jobs. All right. So I hone on this all the time. You got to treat for all impairments, big and small, because small ones can still be severe and usually are, if they're well treated and if you have symptoms and you report your symptoms to your doctor and you're getting treated for them. So I continue to see people who say, well, I was diagnosed with this, I just can't go to the doctor, and da 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 da. Well, then there's no proof of what those symptoms and limitations are there. There just isn't. There's no medical proof. So, or it's very, very light and limited. The functional limitations are what develop the RFC. The diagnosis does not. So while you need a diagnosis in order to have a severe impairment, first have to have a diagnosis. That diagnosis is not going to get you your RFC. You're still going to start out with a person with a perfect RFC, Superman, Superwoman. It's those evidenced functional limitations that stem from X, Y, or Z diagnosis or severe condition that starts carving away the functioning so that you're left with this kind of functioning. And guess what? No jobs are available with someone that can do this, but not this. And that, if it's severe enough, limited enough. And again, your vocational profile is going to have an impact on what you need your RFC to be, to look like, in order to find you disabled. And when you're under 50, and we have videos on that, so just look up 50, I think, younger individuals, it's a much steeper mountain to climb, right? Okay. She has a cute little add-on. She goes, so what do you think about this decision? Also, did you think of the Twilight Zone theme song when you saw Zone of Choice? No, just me. Okay. Well, then I am definitely ready for my Thanksgiving break. She's so cute. Okay. What a great attitude. And does such a great job. All right. So Sixth Circuit, Robbins versus Commissioner. A upholding of the denial of SSI for a younger man with autism and the reasons why. Chat with you later. Bye, guys.